This meeting is recorded, as the Zoom message is probably telling you. CNDR is very proud of John Landy joining us today. He's an alum and an so glad he could join us. We ask that please mute your microphones until you need them. Great. CNDR, in addition to having courses for students and trainings for practitioners, enjoys a really wonderful mediation clinic run by Carol Azumi and Gail Silverstein. We also have an ADR team, a concentration in resolution. And we put on a number of events such as this, so welcome. John will discuss his book and ideas for about 20 minutes. I'll ask a few questions and we'll open it up to others to ask questions. You're very encouraged to use the chat, but I think maybe we're small enough that you could also raise your hand, but just to be sure, you might put your questions in the chat. Well, I first met John in the mid-'80s when I was a student here at UC Hastings, and I applied for a Hastings Public Interest Law Foundation grant, and he was an alum who was involved in picking and choosing. So I got my grant, so I have John to thank for that and for so many things. He's been in public service and educational efforts for decades, both as an instigator and a collaborator. He's very involved with the Indisputably blog that many of you are familiar with. But now for his formal bio. John is the Isidore Loeb Professor Emeritus at the University of Missouri School of Law. He got his JD at UC Hastings. He got a PhD at the University of Wisconsin-Madison, and he began practicing law and mediation in California in the mid-'80s, or excuse me, in the '80s. He directed a child protection mediation clinic in the '90s. The ABA has published his book, Lawyering with Planned Early Negotiation, How You Can Get Good Results for Clients and Make Money. He's also written a book that he'll be touching on and speaking to a bit today, which is called Litigation Interest and Risk Assessment. Help your clients make good litigation decisions. This was co-authored with Michaela Keat and Heather Even. And with that, I am going to turn it over to John.
Well, thanks very much. Oh, go ahead.
I'm sorry. And let me introduce Hind Al-Jabara, our Senior Academic Program Coordinator, who's going to be helping with all things Zoom, and Maddie Robertson, our Deputy Director, who's also assisting. Thank you.
Thanks very much, Sheila and Maddie and Hind, and for the invitation to give this talk, which I've been really looking forward to. I'm thrilled to see a number of friends I've known for a long time and others who I've met along the way and others who I'm just interacting with for the first time today. So I'm going to do this PowerPoint, and as Sheila said, the plan is it will take maybe 20 minutes or a little more perhaps, and I'm leaving a lot of time for conversation. Fortunately, you can't throw rotten tomatoes through Zoom, but I'm ready for hopefully whatever comes my way. So here we go. And we're gonna start with this slideshow. Okay, so I titled this How to Combine Positional and Interest-Based Negotiation and Facilitative and Evaluative Mediation, because these are terms that are very familiar in our field, and I thought it would get a bunch of attention, and apparently it did. So thanks for the folks here at Hastings. As Sheila said, you can put questions and comments in the chat, and we'll get to them after I finish the talk. And also, especially the group is small enough that we can talk, so you don't have to just type things in. You'll see that this PowerPoint has links to various publications with more detail, and we'll provide you a copy. I know a lot of you are probably diligent students and wanting to take notes as we go along, but you'll be getting a copy of this PowerPoint. So the basic premise here is that we need good language for good theory, and that we have rotten theory now, in my opinion, a basic theory, and I'll explain why. And it's important because theory guides actions and concepts are the building blocks of theory. And so if we have this positional and interest-based negotiation or facilitative and evaluative mediation, those are concepts, these are frameworks that people have in mind, and they may orient their behavior towards that. And as I will describe, I think that they are very confusing and counterproductive. So, and it's a problem because if we use different language for similar concepts or the same terms for different things, then we are confused. And part of the idea here in our field is we're trying to help people understand things clearly. And I think that our language actually makes things worse. So professional jargon is helpful in some fields because it promotes communication between professionals. So if you have rocket scientists or brain surgeons, it's really helpful that they have jargon that they can communicate with precisely and clearly, and they understand each other. Our field is a little different because we have communication with people who are lay people, and it's really important that we're dealing with a wide range of stakeholders. And you know, we're not rocket surgeons. We don't need to have this very specialized jargon to be able to understand each other. There's some plain language which I think would help us and the range of stakeholders that we are dealing with. So some of the benefits of clear language, it could improve communication with disputants and other stakeholders. It could help students navigate worlds of practitioners, clients, and faculty. I think about students in clinical programs, and that's exactly what they need to do. We're teaching them how to deal with clients, and they are dealing with practitioners on the other sides of a case. And of course, they're also dealing with the faculty, and these three sets of stakeholders have different ways of thinking and expressing themselves, and it would be useful if there was some common language that people could generally understand. Clear language could also promote collaboration between researchers and practitioners. And for those of people who are focused on research, it could also provide standard keywords for research. Last year, there was this symposium at Pepperdine, and in preparation for that, I did, in some ways, a very basic study or search for publications in our field, and it was just overwhelming, and it was really hard to find all this stuff and identify how things related to each other. And in doing bibliographic research, it would help if we had some standard keywords. So if we had clearer, more commonly understood language, it could provide the kind of benefits I've just listed here. And our field is a Tower of Babel. And I learned this, of course, I have taught for many years, and I would be explaining these concepts to students, and I often got tripped up as I was trying to explain how these concepts worked in the real world and answer their questions. Now, of course, part of that may be that, you know, everyone knows that I'm not a really good teacher, but beyond that, these concepts are just really hard to explain. And so that was one tell for me that we had some problems. Another one was I did a review of negotiation texts as a background for a study I did where I interviewed lawyers about cases that they had settled recently, and I was looking for the concepts and the models to see how to frame the questions. And what I found was that there was a tremendous amount of confusion about the negotiation models and even the definition of mediation in these texts. And you can see here's an example of a link that you can follow if you want to look at that. And following that, I organized this Tower of Babel symposium at the University of Missouri, where I've been teaching, and that goes into more detail about this. And then some of you may be familiar with the task force on mediation research that the ABA section of dispute resolution sponsored, and it came out with a wonderful report in 2020 2017, and it demonstrated confusion about mediation models. One of the things was that, this evaluative model, they found that in looking at these different studies, and they had looked at 47 studies over the last 4 decades that did empirical research about mediation, and there was just a long laundry list of different words that people were using for things that were like evaluative mediation. They also found, as I'll show you shortly, that the things that people identify as being evaluative mediation, people view them differently, and they are different. So going back to negotiation, the negotiation texts refer to 2 models, and they go by lots of different names: distributive, competitive, adversarial, positional negotiation. Another one is integrative, problem-solving, cooperative, or interest-based negotiation. So here's your Tower of Babel, all these different terms that are essentially synonymous. Maybe you can identify some, and there are some very fine distinctions between them, but people use them more or less interchangeably, and they're very confusing. And not only that, they completely overlook a common pattern, which I found in that study I told you about, where I interviewed lawyers about the negotiations that they had done recently. And probably the most common pattern, certainly more common, I think, than the interest-based approach, is what I called norm-based or ordinary legal negotiation, which completely flies under the radar. And let me tell you some examples of where that is. So in family cases, if you have, and basically what norm-based or ordinary legal negotiation is about is, unlike positional negotiation, where you start off with extreme positions and there's an exchange of offers and counteroffers with the idea that each side's going to try and get partisan advantage to end up with the most favorable solution. And of course, interest-based negotiation, where theoretically people are going to identify their interests and then identify options and then pick the option that best fits the interests of both parties. Those are the 2 classic models. Well, norm-based negotiation is something where the negotiators will be focusing on what the typical common patterns are. So for example, in divorce and parenting negotiation, you have child support schedules. And if you plug in the amount of income of each of the parents and the number of kids, voila, it pops out a number. And sometimes there's negotiation over that. That's the presumptive child support amount, but they may argue that it should be a little more or a little less than that. It's not the positional negotiation. They're not starting with extreme demands, and it's not an interest-based approach. They're not saying, well, this is my interest, that's my interest. They're saying, well, this is what the norm is. And you see it in lots of different contexts. Parenting schedules, there are norms. In plea bargaining, it's very common to have this in some smaller personal injury and contracts and lots of different kinds of things. So these models are very problematic. And it's better to focus on some variables rather than the models. And so you can see that what I found here in analyzing these models, they were based on actually 6 different variables. And so in the adversarial model, it's assumed that the parties have goal of maximizing their own results. They have zero-sum assumptions. They treat the other side as hostile opponents. They use the counteroffer process. They focus on the BATNA outcome as the norm that they're orienting to, and that they're using various hard bargaining tactics. Now, one of the things that I found was that that these models, the cases, in fact, didn't match all the time. So, for example, there were a lot of cases where you had this counteroffer process, but the lawyers were treating each other very politely and respectfully. They didn't use hard bargaining tactics. And if you could go through the counterpart variables or values of the variables for the interest-based negotiation, and you again see that all these variables didn't necessarily correlate with each other. And these models are assuming that you have this whole, it's a package deal, you get all of it. And in fact, as I described, that isn't the case, that negotiators use different models for different issues or different models at different times in a case. So let me tell you about one case that that a lawyer I interviewed told me about. It was a divorce case, and there was they had to the husband had lost his job and couldn't find a job at a comparable level, and so they had to sell their house, and they used what we would call the interest-based approach in figuring out how to make arrangements to sell the house. There was an issue about support, and they had this positional approach about support. So, you know, they were kind of going for child support, going back and forth about that. And for the parenting arrangements, it was very much the norm-based or ordinary legal negotiation. They pretty much accepted what the typical pattern for parenting negotiation was. So you couldn't say that it was a positional or an interest-based or a norm-based model. It was a combination. And so what it suggests is that these models are problematic. And here's a link to that article for those diligent students who are definitely going to want to read it all. Actually, it's a very interesting article. I describe in some detail these various cases that were actually negotiated. So we have some babbling mediation models as well. And Len Riskin's original concept combined a lot of very different variables. Len was going to be on the call on this program or attend, but unfortunately couldn't participate. And you can see that some of the things that the model, the facilitative and evaluative model combined things like giving a case analysis, such as including strengths and weaknesses of a case, recommending specific settlement, making prediction about likely court results, and applying pressure to accept specific solutions. I was part of a task force of the ABA section of dispute resolution on improving mediation quality. We did a survey of mediators in 10 different cities, and we found the various percentages of people, of mediators, thinking that these various techniques were appropriate or helpful in most cases. And you can see that there's a range of reactions here. And then just analytically, these are very, very different activities. Giving a case analysis is very different from recommending a specific settlement, which is different from making a prediction about court results. And they're certainly very different from applying pressure to accept a specific solution. So much like the model for negotiation, you have this package deal where it's assumed that all these things necessarily go together as being evaluative mediation, when in fact they are not in practice. So what should we do with our models? Sheila said that my original PowerPoint was too text heavy, so I added this slide. This is this is what I think we should do with our models. I think we need to trash them and replace them with some variables, which I'll describe to you. So there are, I think what our field is about is helping parties make decisions, often when they lack good or any practical dispute resolution options. So for example, we help parties choose a process. So this is one of the things that lawyers should do and do to say which of these processes or a variety of others would be most appropriate for you. We help them design the process by making procedural agreements. And of course, particularly in the mediation context, this happens more and more. And then of course, we help parties make decisions in a case about specific issues. So that's one set of variables we can think about in terms of the sorts of things that we want to discuss and have practitioners orient their activities towards, and then also explain to their clients and other stakeholders. And then here's the book that Sheila mentioned that I co-authored with two wonderful Canadian colleagues, Michaela Keat and Heather Haven. And it provides this useful three-part structure So in analyzing a case, we say that lawyers and mediators and parties should think about the expected value of options, which are also known as alternatives to negotiated agreements, tangible costs of continuing to go through the litigation process, and then intangible costs and interests related to the litigation process. And by doing so, you can help the clients make better decisions about negotiation, mediation, litigation. And originally, when I discussed this idea of doing this talk with Sheila, it was going to be about this book, and you'll see that I'm mostly not going to be talking about the book, although I highly recommend it. I know the authors, and I think they're really good. And the very last slide in this PowerPoint, which you will get, includes a link for more information about the book and where you can get a 25% discount on buying the book. But that's mostly what I'm going to say about it. So negotiation and mediation can focus on these factors. So here's a framework that I think may be useful, and they illustrate some variables to describe cases which may change during a case, and some, they're not a package deal. Some are related to others in some, but not all cases. So you can see in this slide, these are the variables from the negotiation models. So you have the goals, which may be partisan advantage, joint gain, or one of the things that's often missing in these models is fairness, which is often a goal or sometimes a goal for parties in negotiation. The assumptions that they make, zero sum, positive sum, negative sum, the attitudes towards their counterpart, which really vary a lot, the relevant norms, again, often it's sometimes you'll see the reference to normal practice in addition to the law or party's interest, the communication process, and a variety of tactics. One of the things that I found in doing the research about negotiation models was that there was in the textbooks, these law school textbooks, was that there's just a laundry list both of dirty tricks and negotiation tactics for positional negotiation as well as interest-based negotiation. So this is one set of variables that we can think about and express. And you can see that these language is, particularly in terms of the variables, pretty basic and clear. So then a second set of variables relates to the kinds of activities that lawyers and mediators can do. This comes out of Len Riskin's grid, and which obviously is oriented to mediators' actions, but these are also relevant to what lawyers do. And these are things like listening, helping parties assess the case, assessing the options, predicting outcomes, giving advice, and applying pressure. Obviously, again, these are not part of a package deal, and you can identify and focus on particular variables and do it clearly. And again, notice that the language here is fairly clear and basic, not the kind of, I'll use a technical term, mush that our jargon tends to use. And then variables about the issues, again, going back to what I described earlier, and the kinds of decisions that we help parties make about what kind of process to use, the procedures in the process, how to resolve the particular issues, and then the various factors that they may use to consider in resolving issues. So how should we deal with this Tower of Babel? The Mediation Research Task Force suggested development of more uniform definitions and measurements of mediator actions and mediator outcomes. And so I suggest that we replace these babbling models with clearer, concrete language. And I suggest that we use a test of this meme I found Googling, explain it to me like I'm a 5-year-old. We probably want to be a little higher level than that, maybe a 15-year-old. But if you consider the fact that we are dealing with populations who may not be highly educated, we're concerned about access to justice, people who have lots of problems and issues, and they may not, hell, don't understand the damn jargon that we use, and the idea that we're going to expect the disputants and our students and people who aren't in our field to use it is just nuts. So I think we should have a standard of trying to explain it to people like they're a 5 or 15-year-old. And although the mediation task force was talking about mediation actions and outcomes, I think this shouldn't be limited to mediation. So I would like to see an initiative to have develop some agreement about a select number of important terms that would improve communication. Now, this wouldn't prevent people from using any language that they want. They could obviously do so, but if there was some common understanding about certain language that we had common meaning, I think that would be helpful. And it might include a review of academic and practice literature, discussion by experts, focus groups, public forum and comments. And although you could see in those tables in the preceding slides, I'd suggested some language, and of course that resonates for me, but I'm not necessarily suggesting that that would be the language that ought to be used, but there could be some initiative, and possibly by organizations like the ABA Section of Dispute Resolution, CPR, AAA, or there could be academic institutions like Hastings Center or the Center in Missouri or all sorts of places to develop this, and it only requires a relatively small number of people. It's something that could be done practically, and I think would have a lot of value. So, and I just posted a blog post that goes into more detail about this, and so you can read it there. So with that, I'm going to stop and open it up to people. So I'm going to stop the share so we can see each other, and turn it over to Sheila and whoever to jump in and see what you think.
Wonderful. Thank you, John. Well, we invite your questions in the chat or elsewhere. Meanwhile, while people are hopefully entering questions in chat, John, what do you think some of the most important ideas in your book on litigation interest and risk assessment involved?
Oh, I'm so glad you asked. I guess, actually, seriously, I am. One of the things that we focus on a lot is going into detail about intangible costs and interests of parties, which lawyers in particular and mediators often either don't pay much attention to or don't pay attention to at all and don't value them. And if you read those chapters, and we also have a blog post that goes into detail about them, I mean, it'll turn your stomach. Being a litigant is just, it's a horrible experience. It's like almost as bad as death and taxes. It is just a gut-wrenching experience. Literally, it can cause physical, medical, psychological harm. It takes over people's lives. And I think a lot of practitioners become inured to it. I mean, this is part of practitioners' daily lives, and we don't necessarily think about it. And although we'll talk about it with the clients sometimes, we don't pay as much attention to it as we should. So, and what that relates to is that people talk a lot about BATNAs, and of course they misunderstand that. And I'm not going to get into my rant about how people misunderstand BATNAs now. Thank you, Anna. But people focus, BATNAs tend to focus on the expected court outcome, which is a really important thing. But in terms of client decision making, they really need to think about the tangible costs, how much they're going to be paying the lawyers and for legal expenses, and the intangible costs and interests of just surviving the litigation. And so in developing a bottom line, you need to consider not only the court outcomes, the BATNA value, but also the tangible and intangible costs. And having the bottom line helps people have a tripwire for ending negotiation. And of course, if you're going to use a counteroffer process, a bottom line is helpful because it enables people to develop a strategy so they can figure out what their first offer is and what their concessions are, so that they will end up in a position more favorable than their bottom line. So for me, that's a really important thing.
Great. Ron.
You have to unmute yourself there.
Hi, John.
Hey, Ron.
I really did appreciate the quick rundown of what I know is a lot of work on your part. Following up on your most recent comments, what I don't see a lot of in the analysis that you gave or in the discussion is getting at those intangibles in a way that recognizes that people are disabled from making the kind of rational choices that a long-time negotiator or a lawyer would make when they're the ones in a fight. And I remember seeing or hearing results reported of a Stanford Conflict and Negotiation Center study 25 years ago, 30 years ago, something about comparing the cases which settle and the ones that don't. And they found a common element in the ones that didn't was what they called the presence of blocking emotion.
Mm.
You know, I don't care if it's my last penny, I'm not going to pay that bastard one dime, or I'm going to make sure that that guy never does this to another woman again if it takes me the rest of my life. Those kinds of things, and I don't see in your outline, and I'd love to hear, what are some common terms for mediation models which really do aim to, one, help people prepare to be rational negotiators if they can, and or joint sessions that when I started mediation, I was just entirely content focused, subtle diplomacy, and I came to realize how ignorant I was of the tools that family mediators have developed for joint session and for getting people to really understand each other and even maybe reconcile to some extent so that they could go on and co-parent for the next 15 years. I didn't see a lot of language, and maybe you have it and I missed it, for really focusing on mediation and or lawyers that are good with emotion.
Well, thank you for the question, Ron. First, I'm going to plug your 20 questions, which gets at that. If you haven't seen it on Ron's website, ronkelly.com, I think, and I guess you can put it in the chat so that it gets at some of that. If this was going to be a talk about the book, well, and actually what I would say is you should read and buy and read the book because it gets into it there. I mean, this isn't really so much about litigation interest and risk assessment as about thinking about how to communicate within our various stakeholder communities or with our various stakeholder communities. We have actually go into detail in the book. There's several appendices, one in particular for lawyers with a whole set of checklists of questions to ask clients just about a whole range of intangible interests. And although I've been kind of relating to this in terms of individual parties, organizations, businesses have a lot of intangible interests as well. And so eliciting those and asking them things that they may not have thought about, because often, as you were suggesting, Ron, people come in, they're angry, they're upset, they're confused, they're not thinking about the full range of things. And lawyers often aren't, just as you weren't when you started mediating. You were focusing on the legal issues, as I think most law-trained lawyers and mediators do. Of course, you know, and even some people who aren't law-trained. You're absolutely right. Buy the book, 25% off. I'm being somewhat facetious there, although the book is there. There's also, we go into, I have a blog post, I give a lot of stuff away. There's a blog post that has a variety of questions along those lines. So anyway, long answer. This wasn't the place where I was going into all of that, but that's really important.
And Maddie, is there something in chat for us?
There are a couple. Let me read our first one here from Richard Levy. How important, if at all, would it be for a mediator to use the psychological concept of loss aversion as studied by Daniel Kahneman and Thinking Fast and Slow, to nudge the parties towards settlement?
Wonderful question. Again, we deal with this in the book, which I highly recommend, and you can get for only 25% off. The first chapter actually talks about why people make bad decisions and really what the book is about. And what really lawyers and mediators are about is to help clients make good decisions. And we have a chapter talking about the ethical duties, particularly for lawyers, but also of mediators, to be helping clients make decisions. That's our fundamental obligation. We obviously act on their behalf. We make decisions, or lawyers make decisions on behalf of clients, but ultimately it's the clients who have to make decisions about what their goals and objectives are and whether they want to settle or take the case to trial or continue in litigation. And so your question about loss aversion and a whole long list of cognitive and motivational biases are very, very relevant. One of the things that we suggest, we talk about a series of studies that you may be familiar with. Probably the most well-known one is Let's Not Make a Deal, authored by Randy Kaiser and others. And the unbelievably shocking findings there, which are replicated in several other studies, are that in cases that go to trial, over 3/4 of the cases, one side or the other gets a worse result at trial than the last side's offer. So imagine this: you're representing a plaintiff. The defendant offers you $100,000. You go to trial and you get a verdict of $50,000. That result stinks. Your client is $50,000 worse off than if they had accepted the offer. Plus, they spend all the time and money after the negotiation to get to trial and all the grief. And then not only that, if you're a lawyer, you have to face a client who is unhappy with you because you told them to go to trial and they got this lousy result. So, you know, the results were something like 60% of cases where the plaintiffs got results worse than the defendant's last offer. The defendants, there were something like 20 to 25% got, end up paying more than the last demand of the plaintiff. Although it's a smaller percentage, it was a larger amount. And so loss aversion is one of those factors, along with a whole host of other cognitive and motivational biases. And so, again, the book goes into some detail about how to work with clients about it. But the essence is, you can say, well, do you want a realistic assessment? Do you want to take the chance that you are going to be making a bad decision to continue in litigation and go to trial and get a bad result? Or do you want to have as realistic assessment as possible about what is likely to happen if you go to trial, not only in terms of the outcome of trial, but also the tangible costs and the intangible costs that you are talking about, Ron? So a long answer. Hopefully that addressed the question about loss aversion.
And while it's not a question, maybe Maddie, you could read the next chat comment, and then I've got a question if no one else does.
Sure, from Karen Lipney at Community Boards. There is also an entire community of mediators and organizations that use a, quote, community model, which is facilitative, no push for agreements, with specific training to work with positions, needs, and interests, including emotions, not legally based. So what are your thoughts on that, John?
Absolutely true. Thank you, Karen. And obviously, I mean, this and my work is oriented primarily towards legally oriented disputes. On the other hand, these variables that I had in the in the PowerPoint could be applied and could be used. So, for example, in community programs, you may want, this actually could be very helpful in the training and coaching of mediators about expressing more clearly what it is that you're looking for. And so, and there are some things, clearly there are programs that are, and individual mediators who are more interested in what is commonly known as facilitative mediation. And I think it'd be a lot clearer to talk with particularly trainees who don't necessarily have a lot of time in the training and a lot of experience to communicate with them more clearly using language like this. So I hope that that makes sense for you. And I see you're nodding your head, so apparently it does. Also, I mean, I'm happy to have answer questions from the chat. I'm also happy to have people, thank you for your thumbs up, have people, speak. But I know we have a couple things in the chat, and Sheila, and then also it looks like Amina, but I'm going to leave you to moderate here. So,
Maddie, is there another one?
I'll read our next question, sure. From Anna and Island. Your idea of unbundling the concept or process of mediation resonates with me. As you pointed out, it is possible to combine different elements for different issues, and no one can be polite in positional bargaining. Nevertheless, do you think that there could be incompatible combinations of the elements of mediation? And if so, how could we address them?
Well, I think that there can be, and these are kind of case-by-case situations where you have to look and see whether they work or not. So for example, there was one case, I can't remember the details exactly that in the study I did, but, it was supposedly, you would think of it most generally as an interest-based negotiation, but there's a lot of tension and hostility. So you might say, well, that doesn't go along, but, I mean, in some ways it's a question about what works for, what makes sense in an individual case. And I guess in terms of both prospectively having practitioners, lawyers, and mediators think about what sorts of interventions they want to do, and then in hindsight, analyzing what worked well or didn't, this unbundling, and I think that's a great phrase, I appreciate that suggestion, may be helpful in saying, gosh, these two things didn't go together well. Maybe it would have been better if I'd done it differently. So hopefully that addressed your questioning. Okay.
Hannah, what do you think? Do you think there could be combinations of the elements of mediations played out differently than what John's describing?
I think it could depend on the context as well. If you have, like, let's say, a consumer who's not aware of his or her rights, then you might have some types of behavior that are not very ethical, or that prevent the consumer from discussing interests, because the process somehow automatically turns out to be very rights-based and rights-focused. But I find it very difficult to pinpoint it, and then, of course, to suggest how to regulate it.
And Anna,
go ahead.
I'm sorry, are you joining us from the University of the Arctic in Norway?
Yes, I am.
Great a year in Norway, so I actually speak Norwegian a little bit. But anyway, thank you for joining us. It's wonderful to have people from all over. So I think there's another question in the chat. Is that right? Or comment, Maddie?
And then Amina wanted to jump in too. So you're all moderating, but I want to make sure I saw Amina had his hand up. So
thank you. The name is Mohammed. Amina is my wife, but I'm using a computer. No problem at all.
Sorry.
People make that confusion. Thank you, John. I don't know if we remember. I think I've met you somewhere, because it may have been at the World Mediation Forum, if I'm not mistaken, in Argentina. It may have been at a conference in California. But I think that the question Karen asked and the response you gave, I started with a training program from England, which was a very Western, individualistic problem-solving model. And I was charged to take this model out to Asia and Africa, to a Muslim community that was diasporic. And we found that initially there was a tremendous degree of aversion, in a way, to the model, not to the notion of mediation. Because, mediation is very deeply embedded in all our cultures: Jewish culture, Muslim culture, Hindu culture, Christian culture. And we found that as the model was going through all these countries, we had to embrace principles like better listening skills, allowing emotions to work their way out. John Haynes, one of your greatest mediating trainers, came to Britain with this concept. But his whole idea was leave mediation, leave emotions out. There's no time for it. Get on with the job. And I do empathize, or rather resonate with what Karen is meaning to say, that when you have a matrimonial problem, when there's been problems for 30 years or 40 years in a marriage, and then you tell everybody, let's sit down and work on the figures, my feeling is you're not going to get a closure. I think there's a lot of things that large part of people's emotions are part of the solution to a problem, whether it's genocide, whether it's family problems, whether it's business problems, whether it's a problem between a family, father and a son in business, and they don't get on each other. And a large part of the world is rather relational. We are emotional beings. We are not robots. And we found that I did this training program in 25 countries of the world. We trained 1,000 mediators. And our trainers were all Muslims and non-Muslims. We had trainers from different traditions, and we were enriched by the possibility. But I just thought that when you're talking about models, there's also this element that not only are the models confusing in their own, but some of the models don't even embrace the world we're living in today, which is made up of so many different cultures, faith traditions, and within systems. Within a system, there is a different level of culture, rural versus urban, educated versus non-educated, middle class versus working class. These are all problems that but I'm sorry, I don't want to make a speech. I just want to say thank you. It's very enriching that Karen brought this point and that you are sensitive to it.
Well, let me thank you for those comments, and I would just kind of elaborate that, I'm not here, this framework that I've suggested is not intended as a prescription in terms of how to do it, and it's certainly not a model. It's to disaggregate or to unbundle the model and to make it easier for practitioners, lawyers, mediators, and others to make judgments about what it is that they want to do and what's appropriate or not in particular situations. And, so I guess I'm just essentially repeating all of that. And so, in the situations you're describing, one might focus on certain elements in, high stakes civil litigation. One would look at different ones.
I appreciate, absolutely. I didn't want to be in any way critical. No, I say I embrace all learnings from wherever they come. But what I wanted to say is that I'm so happy that you've been able to do the work you've done to show that models can be so confusing. How does a newcomer come and understand what's facilitative and directive? How do you deal with emotions? How do you deal with the power of apology? So your work, I laud it, and I say it very sincerely. But what I was saying that we also have many diasporic communities, so there's an extra layer of complication which may need future thinking.
Sure, and I think the intangible costs and interests really, in some ways, get at the kinds of things that you and Anna and Karen were all talking about. Sheila, you had a question that you wanted to ask.
Oh, I just was going to go back to more pedestrian questions around techniques for lawyers to help clients make good decisions. Did you want to offer any? And likewise, techniques mediators can use to help clients make good decisions. So kind of pulling it out from the more general to sort of implementing some of this.
Sure. Well, I guess in general, I would say buy and read the book, because that goes into a lot of detail, and there's a variety of ways that people can do it. And if you think about the list of, I don't want to put up the PowerPoint again, but the range of activities that practitioners can do, starting from listening and helping the clients make their own assessments, to assessing the the strengths and weaknesses of the case. Again, there are appendices in the book that do that. In terms of mediation, part of it is these days there's an awful lot of work that goes on before people convene. And so we have an appendix that talks about what sorts of information might be provided ahead of time in writing and in conversation. And then the sorts of questions that mediators might ask, which would be much like the ones that the lawyers would ask, although mediators have less opportunity and their role doesn't necessarily permit, it isn't quite as appropriate. So, well, I'm not sure I can, why don't I just leave it there, particularly since it looks like Paul wanted to jump in, if that's okay.
Yeah. Oh.
From the standpoint of a teacher in law school, but more actively as a practitioner, in answer to your question, Sheila, what I do, and it's from whether it's a high stakes case to, I don't know, a simple or low stakes case. Typically in Michigan, we get pre-mediation statements that gives us a little bit of clue into what the case is about. And in preparation for a mediation, I maintain lists, which I've shared with John. I have it broken down a little differently. I have a list of intangible, non-monetary interests and a list of litigation risks and what do I call it? Litigation factors and consequences. So based on what I know about a case ahead of time, I will go through that and make a couple of charts. One is a chart of interest, and I try and identify interest for each side. Let's take a simple side of the case, interests of the plaintiff, interests of the defendant, and then a third column with mutual interests that on occasion I go back to during the mediation itself to try and energize and focus people on, you're not really that different. You have the similar interests, you're just coming about it in a little different way. That's one thing I do. And the other thing I do is I literally map out each case on one sheet of paper. I used to do it on legal size paper. Now I've gotten it down to letter size paper, and maybe someday I'll get it down to the little 5x8 pieces of paper. So I map out these different interests, these different litigation factors and consequences. And I also do a separate sheet on liability and damages and causation. But honestly, I start out with the page on the interest and the litigation factors. And it amazes me, no matter how much time I spend reading pre-mediation statements, summary judgment motions, deposition transcript, and all the other crap that people attach to their pre-mediation statements, invariably all of that time is wasted, in my opinion. And if you spent more time on the interest, you're going to get a lot further, because a lot of times they'll burden us with lots of material and they never even talk about it. Or you can dissuade them from talking about factors and, liability and facts and damages. One last suggestion, in answer to Sheila's question, I routinely send out with my scheduling materials. And again, for high stakes case or simple low stakes case, it's the same thing. If you're going to be aggressively adversarial and accusatorial and hitting everybody's hot buttons and calling everybody names, don't waste your time. Don't waste your client's money. Give me 2 or 3 pages, up to 5, maybe if you want, bullet point only, no full full sentences, no full paragraphs, just hit about a half a dozen areas of interest for me and stay away from the aggressively adversarial. And more people are doing that. And you get it. And one of those factors is underlying interests behind positions. So I think there are practical ways that you can address that and focus and refocus the parties on interests instead of positions. It works for me.
Yeah, briefly, I want to, first couple of things is to thank Paul, who actually did give me the long laundry list of things that he considers, and we incorporated some of those ideas and organized them differently. I want to show you, here is part of one of the appendices in the book, and it goes into what people might provide in advance in a mediation. Obviously, this is in a litigation context, and so it wouldn't be appropriate in some others, but you can see these are really more objective sorts of things: identities of the party, nature of the claim, itemization of damages, pivotal legal issues, separating disputed facts and undisputed facts, procedural history, status of discovery, history of negotiation, identification of individuals expected to attend, and critical documents. These are things that we suggest would be good to include in writing, and then having confidential conversations about more sensitive things that lawyers may be less willing to talk about. So how the mediator could be most helpful, talking about strengths and weaknesses of the case, personalities and dynamics, whether the parties will or might continue their relationship, potential barriers to agreement, non-negotiable issues, issues where negotiation is possible, realistic estimate of additional legal fees, and interests of each parties that might prompt them to accept a less favorable financial settlement. So this is just one actually small example of some of the very specific things that we talk about.
Great. Well, I think someone was asking in the chat if it's possible to share that list along with the PowerPoint. We'll definitely be sharing the PowerPoint. Just so you know, John, she says she will buy the book. So you don't need to say. Anyway, we have time maybe for one more question or comment. I see one of your former professors is here. I don't know, Mark, if you have any comments about John's trajectory since you knew him as a student many years ago, but it is fun to have him back.
Hey, Mark.
Yes, I thought it was just a terrific presentation, and you are far more expert in this field than I am. But when I taught my problem-solving course, John was a law clerk when I was the director of the Lawyers Committee way back. And I, in fact, wound up using often in the kind of exercises I would do, which sometimes were around a mediation or negotiation. It wasn't mainly a mediation notion, the mixing of different kinds of models. I found that very useful, and also very useful when I was supervising clinical students and we would have some negotiations. And so it was great to see how you articulated that issue. I think it's very important in terms of having the flexibility when you're trying to help parties resolve matters in what will in the end be, you hope, their mutual best interests.
Great. Well, with that, I want to ask you all to join me in thanking John, both for the book and for his leadership in this field for decades, and for joining us today. Thank you, John. Thank you
all.
We'll be doing a few more of these sessions in the spring. We have your emails, so we'll invite you. We hope you'll choose to join us. And until then, take good care, especially next week. Call on all your resilience to deal with whatever's coming. And thank you for joining us.
Thank you.
Bye, everyone.